This is a cautionary tale. What did I do wrong, and what can you learn from my mistakes? So yours truly has been a bit of an idiot. There was a situation before I became an attorney where I had a problem with my former employer, and I sought to file a claim via an employment attorney. And it did not really go that well for some reason. I thought I had a pretty good claim. My attorney told me that I had a really good claim. I borrowed some money from my parents to hire this attorney for many thousands of dollars, and then really nothing really happened. He wrote one letter to the Equal Employment Opportunity Commission, which then took a month or two to get back to us and say, well, we don't know whether you have a claim here, but you've got the green light to go ahead and file some kind of lawsuit or something. And then he never filed the lawsuit. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. And so I was kind of left high and dry in Pennsylvania, mostly because of Donald P. Russo here, who we are going to discuss. So, December 6, 2017, petitioner, who is the Office of Disciplinary Counsel, petitioner would be like plaintiff, charged respondent Donald P. Russo with violations of the rules of professional conduct, which are the lawyer's rules of professional conduct, in connection with his representation of two clients in separate matters. Respondent filed an answer January 16, 2018. The committee conducted a disciplinary hearing on April 13th, 2018. Respondent appeared on his own, no lawyer, and testified on his own behalf. He presented no witnesses and introduced an undated, unmarked letter. The committee recommended that respondent be suspended for a period of 5 years. Respondent Donald P. Russo was born in 1952, admitted to practice in the Commonwealth of Pennsylvania October 20th, 1977, and maintains his office at Bethlehem, Northampton County, Pennsylvania. Respondent has a background in commercial law and worked for a bank for 7 years. He concentrates his practice in labor and employment law, litigation, commercial fraud, and domestic relations. Robert Moore is the first client. He was employed by Air Methods, an air transportation business, as a helicopter pilot. On January 5th, 2012, the union filed a grievance on his behalf, alleging that Air Methods had discharged or fired him without cause in violation of his collective bargaining agreement. That's supposed to be agreement. On April 5th, 2012, the union's representative notified Mr. Moore by email and letter that the union would not assist him further in his grievance. This is very important, not for this whole older thing, but this date that they notified him is important in the law because it starts the 6-month statute of limitations. December 16th, 2013, 14 months after the statute of limitations had expired, respondent, the lawyer, Donald Russo, initiated lawsuit on behalf of Mr. Moore by filing a writ of summons in the Court of Common Pleas of Carbon County. The writ was never served on defendants. March 4th, 2014, 17 months after the expiration, respondent filed a civil complaint. Because the complaint had been improperly filed in Pennsylvania State Court, the action was removed to the United States District Court for the Middle District of Pennsylvania. Air Methods then filed a motion for judgment on the pleadings, alleging that Mr. Moore's claim was barred by the statute of limitations. The judge in June of 2014 converted the motion into a motion for summary judgment and permitted discovery limited to any material pertinent to the statute of limitations issue. Respondent, on November 20th, filed a brief in opposition to the motion for summary judgment. In the respondent's brief, they offered, among other things, no serious argument that the plaintiff did not receive the notice on April 5th, 2012, that the union would proceed no further with his grievance. So then Air Methods filed a renewed motion for summary judgment and a motion for sanctions, alleging that Mr. Moore, through his attorney, violated Rule 11 of the Federal Rules of Civil Procedure by filing and prosecuting a frivolous complaint, which is basically, Rule 11 says a lot more than that, but that's the one of the things of Rule 11 is that you are signing a complaint that is, you've done your due diligence and it's a fair and honest accounting of your claims. On December 17th, 2014, the judge granted the motion for the union to join the sanctions motion and entered summary judgment July 10th, 2015 in favor of the union and Air Methods, on the basis that Mr. Moore had unequivocal notice of April 5th, 2012, that the union would take no further action, etc. The judge granted the motion for sanctions to the extent that it sought a determination that respondent violated Rule 11 by proceeding against the defendants without a factual basis for doing so in light of the applicable statute of limitations and facts indicating that Mr. Moore's cause of action had accrued, imposed a sanction upon respondent of a public declaration, so just basically a public admonishment, directed Mr. Moore's case be closed. The judge said this is a case where the plaintiff's claim was patently unmeritorious or frivolous, patently meaning on its face or on its outside, so that some form of sanction is appropriate. On August 7th, 2015, respondent, remember this is respondent is the attorney, is this Donald P. Russo suspended attorney. August 7th, 2015, respondent filed on behalf of Mr. Moore an appeal to the Third Circuit Court of Appeals. Respondent did not appeal the sanctions order. Associates of the defendant provided formal notice of their intent to seek sanctions against respondent and Mr. Moore for the frivolous appeal. The union also intended to seek sanctions. Respondent filed a concise summary of the case October 25th, 2015, raising just one issue, that Mr. Moore's breach of contract was not time-barred. Mr. Moore's breach of contract action, was not time-barred. By email, respondent lawyer advised Mr. Scully and Mr. Davidson, for the defendants, your recent letters raising the issue of Rule 11 and bad faith were themselves sent in bad faith. Rule 11 must never be used as a litigation tactic for intimidating opposing counsel from asserting a meritorious position. To the extent that your respective letters were intended to chill my client's statutory rights, they are utterly inappropriate. They go back and forth a little bit, and then they agreed, I should have highlighted this part, they agreed to dismiss the appeal. That client never actually filed a disciplinary complaint or bar complaint against the attorney. Now, there's a second matter here relating to a Mr. Keister. We're going to skip a lot of the facts of that, but I want you to add up here. So, Mr. Keister paid Mr. Russo $4,000 on one occasion. This was an Equal Employment Opportunity Commission charge of age discrimination, when, if I recall my reading of this correctly, what's really happening is the employee just wanted a management position and was unable to get a management position, so they filed a claim of age discrimination. So then another $1,800 and another $150. On March 20th, 2012, Mr. Keister had a phone conversation with a union representative stating that he wanted to make his position a management job. He never contacted the union representatives to request reevaluation after being denied, never filed a grievance or requested an official grievance be filed on his behalf for reevaluation. He did not exhaust the CBA's grievance procedures in connection with his request for reevaluation. This is important. In employment law and other areas of law, you have what's known as administrative remedies or required remedies or required actions that you must take before you can file a lawsuit. Kind of like making a copyright registration application before you're allowed. Actually, you have to now have it registered, right? Because of the, Fourth Estate case. So you have to have a copyright registration in hand before you can sue. Same thing here. You have to have followed the proper grievance procedure before you're allowed to sue under, in this case, the bargaining agreement. Another $150 paid. Actually, you know what? You don't have to keep track of it because I think they total it up at the end. The EEOC dismissed Mr. Keiser's charge and dismailed him and mailed him a dismissal and notice of rights, which is known as a right to sue letter. Now you have the right to sue. A subsequent lawsuit must be initiated within 90 days of receipt of this notice. The lawyer was paid another $4,000. The complaint was required to be filed by December 3rd. He was paid another $350. The respondent lawyer filed the complaint January 17th, which is obviously after December 3rd. respondent wrote to his client saying that they had a strong case and asking for more money, another $4,000, another $2,000. The attorney for defendant, the PPL Electric Corporation, filed a motion to dismiss, alleging that the plaintiff had not set forth even a bare-bones case for age discrimination, but yet the defendant or the respondent lawyer expressed his confidence that the matter would be resolved in 6 months or less. He emailed his client in 2013 saying, if we litigate this case for another year to 18 months, I expect your fees and costs will be in the $20,000 range. This is a lot of money, but it is a big case with large amounts of money at stake. Frankly, I think we got them on the Lilly Ledbetter Fair Pay Act of 2009. What I would like to do is present a cost adjustment proposal. If you are amenable to paying $7,500 now in advance, I will accept that payment in lieu of any further billings. Respondent replied to Mr. Keister's May 22nd email about it taking 18 more months by stating that he was confident the judge would throw out the motion to dismiss. Mr. Keister paid another $2,500. Respondent filed a motion for leave to file a Second Amendment complaint, then wrote to his client, as you see, as of today, there is still no decision on the motion to dismiss. However, I think we will hear this week, and I am certain it will be positive for us. I feel badly for you that the judge has eaten up so much of your time. I am offering to cap your legal fees for one final payment of $2,500. If you want to place a cap on all future billings, please forward a check to my office for the amount, and I will institute a cap. He made a check for one final payment of $2,500. Although respondent promised to cap his fees, he would go on to collect an additional $21,660 from Mr. Keister over the next 4-year period. So we're going to skip ahead because there's a lot more of this. $500, another $500. I think we nailed it. Ernie, if you would be so kind as to forward payment for $1,250. Please forward a check for $3,500. Finally, the judge grants defendant's motions for summary judgment, outlines in details why Mr. Keister's claims were meritless and should fail on procedural grounds, explains why Rule 11 sanctions were appropriate. Yet still, the lawyer collects another $1,810, another $96. The judge goes on. An award of reasonable attorney's fees is the least severe sanction needed to deter respondents' improper conduct. Absent respondents' attempts to manufacture facts, warp the law, and utterly cloud the actions underlying allegations, this case would have disappeared long ago, saving defendants, the court, and the public significant time and money. This court was led down the garden path by respondent when it accepted respondent's client's allegations in good faith. The allegations made by respondent turned out to be patently untrue, but respondent chose to plead them anyway in attempt to prop up respondent's client's deflated claim. The allegations in plaintiff's Second Amendment complaint were unsupported at the time respondent wrote them and were unlikely to ever gain factual support during the course of discovery because they were simply inaccurate. It became patently clear that the plaintiff's case was nothing more than an illusion, one supported by baseless factual contentions and inapplicable legal conclusions proffered by the respondent. The theories that respondent conjured up in respondent's papers in this case have not been motivated by novelty or creativity, but by a desire to confuse the court and the parties, to shroud the straightforward weakness of respondent's client's claim, and to manufacture disputes where none existed. It was patently clear to the court that the purpose of this litigation was to extort a settlement from defendants on meritless facts and to otherwise run up the cost of litigation for opposing counsel. It was apparent that the primary goal in bringing this litigation was to obtain a settlement to which respondent's client was not rightfully entitled. The conduct of respondent here and in recent related proceedings has risen to such a troubling level that this court would be failing its duty to the public by not somehow addressing and attempting to adequately deter it. Yet, the client paid another $750. Then the judge goes and orders the respondent to pay $58,000 for the Rule 11 sanction motion and another $58,000 for the unions, so one for the electric company and one for the union, and the clerk of court to enter final judgment and close the Keister matter. To date, respondent has not paid either party any portion of the sanctions. Yet, he was still able to get $1,500 more from the client. He filed an appeal to the United States Court of Appeals for the Third Circuit. He got another final payment of $3,000 from the client. January 27, 2017, the Third Circuit issued an opinion affirming the grant of summary judgment and the grant of the Rule 11 sanctions motions and the Rule 54 motion for fees. They agreed there is nothing novel about the type of claim alleged here, or the theories that Mr. Russo has conjured up by a desire to confuse the court and the parties, to shroud the straightforward weakness of his client's claims, and to manufacture disputes where none existed. Mr. Kaiser's claim against the union was unequivocally lacking in merit, substantively frivolous as it related to his failure to show any breach of the union's duty of good faith representations, wholly contrary to Third Circuit case law, and related to mandated procedural exhaustion in the law. It is factually baseless. February 7th, 2017, respondent filed a petition for rehearing en banc. The Third Circuit denied the petition, but the client still paid $2,100, $800, $3,000, $2,900, and $300 between March 2017 and May of 2017. The respondent filed a petition for writ of certiorari to the Supreme Court of the United States in connection with the Third Circuit's January 27, 2017 order. The client paid another $1,500, and then the Supreme Court denied the petition for writ of certiorari. Mr. Kaiser paid respondent at least $39,206 in connection with the PPL matter. Mr. Kaiser never filed a complaint against respondent. So there's a little bit of previous disciplinary history. Previously, July 13th, 2010, respondent was non-responsive to his client's numerous inquiries and prompted his client to terminate his services, receive a refund, and file a disciplinary complaint. He received a private reprimand October 11th, 2011 for failing to provide his client's written statements setting forth both rate or basis of fee. He received retainers in advance, yet he deposited them into his personal or non-IOLTA account. After his clients terminated his representation, he refused to return their money, compelling them to file a civil complaint. The arbitrators found against respondent, and he had to return $6,250 to his clients. He received a public reprimand December 14th, 2015. Over a 5-year period, he committed egregious procedural errors and failed to prosecute his client's federal court qui tam action, resulting in the action being dismissed with prejudice, meaning it can't be filed again. Secondly, respondent allowed his professional liability coverage, his insurance, to lapse for 5 months, which he's allowed to do, but he has to notify his clients, and he didn't. He also has to notify the disciplinary board. Respondent failed to appear at a disciplinary hearing for someone's employment, and their employment was terminated. Respondent failed to appeal the termination, instead filing a federal lawsuit alleging a violation of her employment rights, which he lost for failure to exhaust state remedies. Remember I said you have to exhaust certain administrative remedies? So he didn't do that, and he just filed the lawsuit. Respondent advised her to falsely answer questions on her new job application. She was ultimately terminated from her new job for falsely answering employment application questions. She commenced a malpractice action in 2008 against him. He failed to timely notify his malpractice insurance carrier, which had lapsed, and they refused to defend him. He settled with the former client by admitting liability, but left it up to a jury to decide the amount of damages. They entered a judgment of over $4 million. Between 2015 and 2017, 4 additional legal malpractice complaints were filed against respondent by former clients. And then we're not even to one of the juiciest parts yet. His own attorney, his staff, Nicole Heritage Esquire, testified that she worked for the respondent from 2014 to 2015 when respondent terminated her employment due to economic downturn. On October 20th, 2015, But on October 8th, 2015, she had already filed a disciplinary complaint against him. She had concerns about his lack of record keeping, improper accounting for money coming into the office. She testified that he had a policy of sending out cost adjustments. Twice a year, he would send out mass letters to his clients requesting payment for items such as postage, printing, office supplies. These costs were not specific to an individual client, as it was a general amount that was requested of every client. After the letters were sent, respondent instructed Ms. Heritage to make follow-up calls to the clients to negotiate payment of these charges. Toward the end of her employment, she testified that respondent was barely in the office and would only come in whenever there was cash there that he would be able to pick up. Respondent failed to acknowledge his misconduct and failed to demonstrate remorse. Wow. So ultimately, he got turned in one more time by his own employee. And I'm going to skip a bunch of the discussion because the discussion goes over everything we just said and then applies the law to it. And I don't know, you guys really don't want to go over the individual lines of the rules of professional conduct, I don't think, especially since we're already 30 minutes into this. Respondent's pursuit of unmeritorious and frivolous claims cost his client a great deal of expense. Mr. Keister paid respondent nearly $40,000 over a period of 6.5 years, of which $16,000 was collected in pursuing appeals to the Third Circuit and Supreme Court. There is no plausible explanation to support respondent's decision to collect fees for what was patently a non-meritorious appeal, and there is no evidence to suggest that respondent advised his client of that fact before accepting these additional sums. The committee found that this matter was aggravated by respondent's willful, vexatious, and bad faith behavior in pursuing his client's matters. And they go on to recommend, believe it or not, the committee recommends a suspension of 3 years to comply with the various laws of they want to make sure there's consistency between opinions of the Supreme Court and the Disciplinary Council. But then if you notice here, the court actually grants a 5-year suspension. So even though 3 years was recommended, 5 years was what was granted. I think the court, I don't know if you were getting that impression as we were going, but each one of these was like, wait, there's another one. Wait, he had another disciplinary action. Just for comparison here, just so, and because I want to make sure that I adequately raise myself up above this guy. I've had over 800 clients, and we don't have any issues of clients complaining. If a client even had something to complain about, I would hope that I've made it clear to them that they can bring it to me and we can fix it. And if they had to file a disciplinary complaint, well, we would eat crow while the crow is young and tender. And if we did something wrong, or even if there was a possibility we did something wrong, we would be taking every action to correct it. Here is the opposite. Here is an attorney who lives on that edge. How much can they get away with? And they weren't doing a very good job of getting away with it. And I'm glad they weren't, because we need to get rid of these kinds of attorneys who don't take the profession seriously, who don't take their duties seriously. We have a fiduciary duty to you. We have to look out for you in your best interests, not ours. I get to charge you a reasonable fee, and that reasonable fee can be pretty darn high, but I have to act in your best interests. So this is a cautionary tale. What did I do wrong, and what can you learn from my mistake? Well, first, I did not research this guy's background. You should go onto the disciplinary committee's website for your state. You can look for the State Bar of whatever, State Bar of Pennsylvania, or Disciplinary Committee of Pennsylvania or something, or Disciplinary Board. You should be able to find the official attorney roles, and there should be lots of information about how to complain about an attorney. If you have had it's one thing to have just a negative experience. It's another thing for there to be dishonesty or sort of taking advantage of the client. The lawyer's not allowed to take advantage of the client. Like I said, we have a fiduciary duty to you. We have a duty to look out for your own best interests. So I can't say, oh, well, you happen to have, a good case, so you should give me lots of money, and then quietly go and make sure the case fails at some point, and then, oh, well, you need to pay me more money because and then quietly make sure the case fails. No. We're not allowed to do that. Honestly, any honest ethical attorney, if they made a mistake, they should be bringing the mistake to the client if it affects the representation. I missed a court date, this is the consequence, it's my fault, I take full responsibility, here's what I propose we do about it, let me know if you have a problem with that, or if there's anything else I can do to fix it. If the client asks, how do I file a complaint, I show them where on the website they can file a complaint, and all that. And because of that upfrontness and transparency and willingness and bedside manner and all that, we've never had a problem, let alone that we don't really make these kinds of mistakes in the first place. We've never neglected a client matter like that, let alone conducted ourselves in a way. This guy was sort of, this is his way of doing business, was to neglect client matters in the hopes of just stringing people along for as much money as he can get. That's a scam. That's not representation. So holy mackerel. So I didn't research his background. He was referred to me by a decent local attorney who is on the up and up and has all the ethics and has all the integrity. So there was no reason for me in my head to believe that I was being taken to, as a mark. And even then, my attorney, my current attorney, sent this to me. So I actually, no hard feelings for my current general practice attorney, who I'm not naming in association with this case. But basically, I did not research this guy. He had one complaint against him in 2008. My complaint probably was in 2008 against my former employer, 2008 to 2010, I think it was. So maybe I wouldn't have caught this. I would have been right on the beginning of this kind of breakdown in his behavior. If this was the beginning, this was when at least he got caught. So yeah, that lawyer was a con artist, says Max Andrew, and that's basically what it ends up being. And that's a problem, because we're professionals, and there's already enough reasons for you guys to not like lawyers. We don't need to have bad actors spoiling the bunch for everybody. And kudos to Nicole Heritage for having the guts to stand up against his unethical behavior. I did not, I guess. What I got through my case, I ended up getting a settlement that barely paid for my expenses. I don't even think it paid for my expenses. And I ended up requesting a small refund from Donald Russo because he had told me I would get a certain amount of an award, and then when the check came through, it was smaller than that, and I made a fuss about the difference, and I demanded that he make up the difference, which was several $100s, but nothing to break the bank. And I really did feel like I had not been served properly by my attorney, but I was also just getting my law license October 20th, 2011, and I didn't want to make waves. I did not know the industry. I do not know the people. I did not know what kind of waves I could make and still have a decent law practice. So I've done this a couple times in my life, sort of. You could argue that it was a cowardly thing to do, to back off of a complaint, because I didn't want to get in trouble, later on down the line with somebody who knew that I had filed a complaint and didn't like me anymore or something. I'm a little more confident now. But back in 2011, when I was just getting started, just getting my law license, I did not have the courage to file a complaint against him. Nor did I think I realize how bad it was. He had done a successful job of silver tonguing, talking to me and talking me out of any concerns that I had. So that was stupid of me, and you shouldn't make the same mistake. What do you think of that story? Leave your thoughts in the comments below, and let me know if you learned anything about not hiring a lawyer like Donald Russo. By the way, 5 years is probably the longest suspension you can get without getting disbarred. I don't think I've ever heard of a longer suspension. 5 years makes sure that you basically have a career-altering change in your life. You're not allowed to practice law again until you've gone and done something else or worked for another lawyer or something. And I don't know who's going to want to take you after this level of dishonesty.
And I think in this circumstance, like, you even had some legal training to give you an idea of what's normal and what's not. But a lot of people don't hire lawyers all the time, and so they're not sure what's normal and how long it's supposed to take, and they don't know what questions to ask. And so, like, if you ever get into a situation where you're wondering if your lawyer is on the up and up, or if what's happening is reasonable or not, like, you're allowed to ask for a second opinion from another lawyer. You're allowed to research the lawyer that you have. Call
the disciplinary board for the state that the lawyer's licensed in and ask them if they've had any complaints or problems. They will tell you if they've had convicted complaints or complaints that have been prosecuted all the way through to a final order. They will not tell you if there's just been a complaint. That's not, it's sort of like the law of the Fifth Amendment due process, where the lawyer has to have an opportunity to respond to the thing before they will just tell you that there's been complaints. You can also use a website like AVVO, AVVO, Alpha Victor Victor Oscar.com. They keep track of lawyers' disciplinary complaints, and their thing is that they try to sell advertising to the lawyers on that site. But you can use that site to find a lawyer or to research your lawyer, look for disciplinary complaints, look for the age of the lawyer's license. So I often talk about it in shorthand. I'll say that I'm a 7-year-old lawyer. And what it means is, to me, is that my license is 7 years old. This is a big deal. This is a bigger deal than what was your bar exam score or what law school did you go to. Is how long have you been practicing and have you had any disciplinary complaints? I've been practicing for nearly 8 years, 7.5 years now. I've had nearly 800 or so clients. We sort of lost track. It's over 700. It's probably over 750. It's close to 800. And we've not had a disciplinary complaint. 8 years and several hundred clients without a disciplinary complaint is like a milestone for any lawyer out there to cross. And you're now into a much safer zone where, as long as you keep doing what you've been doing, you shouldn't have any. You should be smart enough to know how not to piss off clients and how to avoid bar complaints. This guy, holy mackerel, to have so many complaints and so many issues in such a short period of time, there is a fundamental problem with his ability to simply operate a business and behave ethically and responsibly, to put his duties to the client before his apparently overwhelming desire to make money and survive. And that is our show, everyone. Thank you very much for joining me, Leonard French, your favorite copyright attorney, for this Cinco de Mayo episode of Lawful Masses. This is a community-supported legal education channel. Thank you very much for your support on patreon.com/ljfrench and sponsus.org/u/lawfulmasses. Thank you very much to our May $50 plus supporters: John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Crisp, Jan Negrey, Spirit Bear, Daniel Perez, Richard Fournier, Snorre Wisotzky, allquixotic, and Aspernari. Thank you very much for your support at the $50 level, and thank you to the $5 plus supporters who are scrolling on the LED panel behind me and will also be in the crawl and the description of the videos that drop. And of course we have a Nico here someplace, if I can get him back. Come on, hup boy, hup, come on, go boy, go boy. All right, everyone. Love you all. I am Leonard French, your favorite copyright attorney, and I will see you this week in the videos that drop. Bye.
Can you feel me?
There you go, good boy. And then we come back.
Can you feel me?
And this will be a pattern that repeats.